Good morning, everyone. We're just waiting for one other councillor to join us, and we'll be starting very shortly. And we've got licensing here. Yeah, we're just waiting for one more person. My name is Luciani Barker, by the way. I'm the clerk, and I help with the procedures.
Just to let you know, Claire Moore is not attending.
Okay.
Luciani, I think Jackie's tried to join
Get in,
the
yeah.
previous meeting, and I'm just trying to.
I'll text her. I'll give her a ring.
Yeah,
Mm.
I think she had. I'm trying to call her into this, but she's in the previous meeting, so she.
I'll give her a ring.
Thank you.
Hi, Jackie. And Bill's got his hand up. I don't know.
He has. He says he's trying to get his camera and mic to
I see.
work.
Mm.
Just while we're waiting for Bill, I can say about Jackie. Every time I try and join her.
She's going to leave and come back. I've just
Right.
talked to her.
Okay, perfect. Because I can't join her, and she asked us to call her in.
Pauline, if you text her, I just emailed her the link. She might find it easier to go on the
Okay.
email.
Yeah, I'll give her another ring.
Oh, hello, Jackie. It looks like we've got you now.
Yeah, she's here.
Jackie, can
Can you hear us,
put your-
Jackie?
You're muted, Jackie, if you can hear us.
Oh,
There we go. We can hear you. Are you able to put your camera on? Oh, there you go.
Bill Fox has left trying to resolve, I think, his camera and audio issues and hasn't come back.
I don't know how to do this. What do you want me to do?
No, you're okay,
You're fine.
Jackie.
You're fine.
Talking.
You're fine.
Which one's talking? I'm all right, am I?
You're okay. You're okay.
Hmm.
You're fine. Oh, hello, Bill. Can you hear us?
Yes, I can. Thank you. Can you hear me?
I can hear you. Okay, so
And we can see you.
Super.
as I said previously, good morning, everyone. My name is Luciani Barker. I'm from Democratic Services, and I'm helping to facilitate the procedures this morning. I'm going to start by asking the panel members to nominate a chair for this hearing, please.
We nominate Pauline Jorgensen.
Okay, Pauline, it's over to you then.
okay. So thank you, Lucian. Right. Thank you very much for coming this morning. So first thing is to for everybody introduce themselves. Can we start with Bill? We'll work our way around. Just say who you are and what your organisation is.
Good morning, everyone. My name's Bill Don from Silver Fox Licensing Consultants. I'm advocate for the applicant today, Bearwood Brewing Limited.
Okay, thank you, Andy.
I'm Andy Goodwin from ZAP. I'm from Unit 12 next door to Unit 11.
Okay, who's next? Lucienne? Okay, Jackie?
Jackie Rance, Shenfield Borough Councillor.
Okay, Kieran?
Kieran Hinchliffe, Service Manager.
What, for licensing, yeah?
Yes.
Sarah?
I'm the planning enforcement team leader,
Okay,
so I'm representing planning today and development management.
Rachel?
I'm Rachel Lucas, legal advisor to the panel today.
And we've got two people on the next one. Peter and somebody.
Peter and Ellen. So we're the owners of Bearwood Brewing.
Great. And Beth?
I'm Beth Rowland, the elected member for Woodley South Lake.
And Alec?
I'm Alec Coomber, licensing officer, Woking Council.
Right, and I'm Pauline Jorgensen. I'm the member for one of the members for Hillside in Early. So thank you very much for coming. First item, has anybody got any interest to declare? That's members of the panel, obviously. Okay, thank you very much. So the procedures are that we want to make sure that you all get the chance to put your viewpoints forward on this license, and as to how it meets or doesn't meet the objectives of licensing. So the four objectives are the prevention of crime and disorder, public safety, prevention of public nuisance, and the protection of children from harm. So the first thing I would like to do is get the licensing officer to introduce the hearing report and update the subcommittee on any developments that have happened since that report was written. So I think it's you, Alec, is it?
Yes, thank you, Chair.
Thank you.
So, members are requested to determine the application for a new premises licence in accordance with Section 18 of the Licensing Act 2003, having regard to the representations received and the requirement to promote the four licensing objectives. The following options are open to the Licensing and Appeals Subcommittee. To grant the application in full and on the terms and conditions contained within the application to include any applicable mandatory conditions. To grant the application as above, modified to such an extent as considered appropriate to satisfy any relevant representations and promote the licensing objectives, or to reject the application. An authorisation is required in respect of any premises where it is intended to conduct one or more of the four licensable activities, these being the sale of alcohol, the supply of alcohol in respect of a club, regulated entertainment, and the provision of late night refreshment. This application was submitted by Bearwood Brewing Limited in respect of Unit 11 Anglo Industrial Park, Fish Ponds Road, Wokingham, RG412AN. The applicant originally applied for the following hours: for live music, 0800 hours until midnight, Monday to Sunday; for recorded music, 0800 hours until 1 AM, Monday to Sunday; for late night refreshment, 2300 hours until midnight, Monday to Sunday; for the supply of alcohol both on and off sales, 0800 until midnight, Monday to Sunday, with opening hours of 0800 till 1 AM, Monday to Sunday. Since the original application, the applicants have wished to amend their application as follows: to amend the hours permitted for the supply of alcohol to now be 0800 hours to 2300 hours every day; to remove licensable entertainment and the provision of late night refreshment from the application; to remove the licensable area for external seating, as seen in the plan attached to this application; and to amend the hours open to the public from 0800 until 23:30 hours each day. The premises is a brewery within a commercial unit with an area intended for the retail of alcoholic and non-alcoholic drinks for consumption both on and off the premises. The operating schedule is completed by the applicant and contains additional measures to illustrate how they propose to promote the 4 licensing objectives as required by provision of the Licensing Act 2003. The following additional licence conditions have been agreed between the applicant and Thames Valley Police to be added to the application. I won't go through them all as they are detailed in your pack, but the conditions include areas on staff training, age verification, CCTV, incident recording, door supervisors, and noise management measures. The responsible authorities included in the consultation for this application are Thames Valley Police, the Royal Berkshire Fire and Rescue Service, Environmental Health, Trading Standards, Public Health, the Local Planning Authority, the Local Safeguarding of Children Board, and Home Office Immigration Enforcement. The representation was received from Thames Valley Police proposing the aforementioned conditions, but following them being agreed with the applicant, the representation was withdrawn. A further representation was received from the Local Planning Authority, which is attached as Appendix D in the pack. The premises currently holds planning permission for B1C, light industrial, and B8, storage and distribution uses only, which do not encompass brewing or retail, and the right to change to B2, general industrial use, has been removed by a planning condition. The revised Section 182 guidance directs that where businesses have indicated when applying for a licence under the 2003 Act that they have also applied for planning permission or that they intend to do so, licensing committees and officers should consider discussion with their planning counterparts prior to determination with the aim of agreeing mutually acceptable operating hours and scheme designs. In this instance, the local planning authority requires the applicants to apply for appropriate planning permission and has requested that, in contrast with the originally applied for hours of 0800 until 0100 Monday to Sunday, the following condition be added to the licence. The use hereby permitted shall not operate other than between the hours of 0700 till 2000 hours, Monday to Saturday inclusive, and shall not operate at all on Sundays or bank holidays or national holidays, which is in line with their planning permission. There has also been one representation against the application from another person with concerns over noise nuisance, antisocial behaviour, and the safety of outdoor customers from regular delivery traffic, which are attached as Appendix E. A response to this representation was provided by the applicant and is also included in Appendix E. Those that have made a representation have been informed of the time and date of the Licensing and Appeals Subcommittee hearing and have been informed of their rights to attend. In terms of legal considerations, the Working Borough Council Statement of Licensing Policy states that planning permission is usually required for the establishment of new premises and the change of use of premises. In general, all premises that apply for a licence must also obtain or have obtained authorised planning permission and comply with all conditions of that planning permission or benefit from permitted development rights pursuant to the General Permitted Development Order 1995. The revised Section 182 guidance states that where businesses have indicated when applying for a licence under the 2003 Act that they have also applied for planning permission or that if they intend to do so, licensing committees and officers should consider discussion with their planning counterparts prior to determination with the aim of agreeing mutually acceptable operating hours and scheme designs. Any decision of the licensing authority on an application for a provisional statement will not relieve an application of the need to apply for planning permission, building control, approval, or building work, or in some cases, both planning permission and building control. Conditions may only be attached to a premises licence where they are deemed appropriate for the promotion of the licensing objectives. They must be proportionate and not duplicate any existing provisions contained in other legislation. The justification behind a refusal or the attachment of conditions must be given to the applicant. The subcommittee is advised that any findings on issues of fact should be on the balance of probabilities, and any decision should be based on the individual merits of the application. The subcommittee, in arriving at its decision, must have regard to relevant provisions of national guidance and its own statement of licensing policy, and reasons should be given for any departure. There is a right of appeal to the Magistrates' Court within 21 days of the date of the applicant being notified of the decision of the Licensing Subcommittee. That concludes my report. Thank you, Chair.
Thank you very much, Alec. Just one question, I think, would either Lucianne or Sarah like to explain the link or not between licensing and planning? And the question from me is, has a planning application been put in?
I'll answer that, Chair. Thank you.
Thank you.
Planning application has not been put in, not been submitted, and I understand also that in amending this licence application, they've taken on board our comments.
Yeah, thank you, Sarah. And sorry, Lucianne, do you want to add anything on planning? Okay, yeah, that's fine.
Yeah.
Sorry, Rachel.
So today, as a licensing committee, you are only able to consider the licence application in line with whether it meets or not the 4 licensing objectives, which you're very aware of. You can't take into account the planning situation. What I would say, however, is in the absence of planning permission for what is being sought, and I don't propose to go into whether the use is currently allowed by virtue of the planning permission that's currently in place, the extant planning permission. Any licence that you were to grant couldn't be used if there were planning conditions preventing that. So until such time as planning had an application, considered the application and granted it, a licence could be granted because you are only considering the licensing objectives, but it couldn't be used in the absence of planning permission. So ideally, they would be dealt with separately. They have to be dealt with separately. Everything makes that very, very clear. But ideally, there would be a little more alignment in terms of the timescales and the consideration of them. But the fact there isn't doesn't impinge on the licensing objectives, and doesn't mean that any licence granted could be used in the absence of planning permission.
Thank you, Rachel. So just quickly to go to the committee, are there any questions of clarity on what the planning officer or Rachel have said?
Not from me, thank you, Chairman.
Thank you. You happy, Jackie?
Yeah, I think.
Thank you. Right, so if we move on to the applicant to give their case, which one of you is going to give it or present it? I think you're muted.
Sorry, so we're hoping Bill's going to step in here.
Okay, great.
Yes. Thank you, Ma'am. This is my application on behalf of Bearwood Brewing Limited. You have the application before you. The original application, as outlined by the licensing officer, originally was for the 3 licensable activities of the sale of alcohol, entertainment and late night refreshment. I'm grateful for the licensing officer and committee services for distributing the skeleton argument, which hopefully all the councillors have read this morning prior to the start of the committee hearing. We have suggested a number of amendments in relation to the licensable activities. So effectively, it nets down to the licensable activity of the sale, supply of alcohol from 0800 to 2300 hours each day. So I'm just going to give some rationale. Obviously, there's been some representations from planning about whether the right planning consents are in place. my clients had been given information by the landlord who issued their lease to say that B2 was in place. Further investigation had found that actually B2 is not in place, and in fact there's some historic restrictions on the license, both in terms of use, limiting it to B1, and yet a microbrewery would require B2. And there are also restrictions on the hours. But as your colleague has rightly said, today you are sitting as a licensing committee. And whilst the Section 182 of the government guidance to the Licensing Act recommends that planning approvals are sought first, of course, that is, you only have to do due regard. It is not legislation. The application for a premises license is a separate process to applications to planning, and you'll be aware of that. If the applicant were to submit a planning application and a premises license at the same time on the same day, then there's different timescales that would apply anyway. Now, my client is cognizant of the fact that they do not yet have the correct planning consent in place. It is common ground that for a microbrewery, one would require B2 planning consent. But furthermore, given that the area allocated within the premises to brewing is relatively small, the rest of the area is a tap room, which would normally fall under Class E, which B1 is within. And so it's easier to transition from a B1 industrial use to a food establishment. But we would suggest actually the correct usage would be sui generis, and that application will be submitted. Now, the original planning application for the industrial estate was submitted to the council back in 2007. And there were a number of local objectors concerned about the lack of amenity should the industrial estate go up. Well, of course, that's been built. It is an industrial estate. It is up and running, and we are 18 years on. So my clients will make an application for 2 points, a planning application, one to get the correct usage in place and to remove the restrictions in respect of the hours. Now, there's no guarantee that should you grant the license today that the planning will grant the planning consent as applied for, and equally if the planning committee were to decide to grant the hours that we've applied for or will be applying for under planning, that will affect your decision today as a licensing committee. I respectfully submit that your concern today is the promotion of the 4 licensing objectives. Now, to that extent, there was a representation from Thames Valley Police proposing a raft of conditions that my client is happy to accept. They are in your bundle around page 51 onwards. They are the standard conditions one would expect for any new application for the grant of a premises license. They are quite robust. They're legally enforceable. And in fact, many of those conditions are already being operated in my client's other business. And I'll come on to that in a moment. There are concerns from Mr. Goodwin, next door neighbour to number 11. And he has expressed concerns which cover planning, health and safety, and potential noise nuisance. We've addressed those concerns in terms of that the brewery is a tap room. We've asked for more limited hours, and we've removed the entertainment facilities within the license. My clients have considerable experience. And firstly, I would call on Ellen, if I may, just to give you a few words about their other operation and how it would apply to this one.
Thank you, Bill. So we currently operate a well-managed, community-focused tap room, and it specialises in high-quality craft beer. Our aim is to create a welcoming, responsible environment for our customers, and we're committed to maintaining those standards with excellent customer service at the core, and with a lot of duty of care to our customers should the licence be granted for this place too.
Thank you.
And then, Peter, if you just briefly touch about the brewing aspect within this business.
Yeah, so the brewery, whilst it's a core part of the business, is actually, as far as the hours go, quite small. So we're looking to brew 5 times over 2 weeks. The central part of the brewing, the main cause of it is only really an hour long. So there's the 5 hours of the activity going on. The rest of it is beer going into a tank for storage. It looks more dramatic than the process actually is, but it's a great experience if you haven't done it before.
And Peter, could you just talk a little bit about the extraction system and where the extract system goes to?
Sure. Excuse me. So we have an element of steam that's produced from the brewing. This is the core part I'm talking about. So the boil takes about an hour. So that's where the 5 hours over 2 weeks comes from. We have a chimney to vent out the steam. And there's possibility, we don't think there is going to be the chance because of the smaller scale of the brewing, but there's a possibility there could be smells attached to the steam. So those smells would be your classic malt smells from the brewing. There are methods to reduce, minimize, or eradicate this, including ensuring your chimney is high enough above the building. So our building is 8 meters at the high point. The chimney could go to that height, and the steam and smell disperses into the high air. Or we can, albeit at a cost that wouldn't be good to us, but we accept it, we could put a carbon filter in line to the steam extraction. The average stats of reducing smells via carbon filters are 90 to 95%. So that's also an option for us.
Yeah, thank you.
Thank you. Then if I've already highlighted that the police have withdrawn their representations because my client has agreed to those conditions. In the original representation, Gary Clark, the licensing officer for Thames Valley Police, didn't express any concerns about crime and disorder or antisocial behaviour in the area. So whilst you can't interpret that as tacit approval, it's generally regarded that the police would be the authority in respect of that. Equally, Environmental Protection and the Fire and Rescue Service have not submitted a representation to this application. And indeed, local residents who would have been aware of the application via the numerous blue notices that were affixed to the exterior of the building and the newspaper public notice, they would have been aware of the application, and no resident, with the exception of the business owner in the property next door, has submitted any representations or objections to that. Mr. Goodwin has raised some valid points in his representation, and my client understands his concerns, and hopefully we have addressed most of his concerns through the amendments of the application, removing the proposed external drinking areas on the car parking bays and the LPG canister. Whilst at the moment it is sitting outside of the property, that will be moved to a concrete hard standing, which is controlled by the estate management company rather than the landlord. So in summary, ma'am, if I may, the application has been amended, and that's been amended to reflect the concerns from the responsible authorities and the local residents. We accept that the business currently does not have the correct planning consents in place. But respectfully, that's not a matter for your consideration today. It's about the promotion of the 4 licensing objectives. Within the conditions of the operating schedule, the conditions address most of the concerns, and certainly they're supported more so with the detailed conditions in your bundle from Thames Valley Police. We think that the operation, notwithstanding the planning consent, will promote the 4 licensing objectives. The planning matter, of course, is a separate issue, and we do recognise that until we've got the correct usage and the correct hours, we cannot operate the business as proposed. Ma'am, that is my submission.
Thank you very much. Have any members of the committee got any questions for the applicant?
I have none.
Beth? You've muted, Beth.
Yes, thank you. I'd just like to query how residents would see the blue notice, and I realise that they've been published in accordance with the rules and the law, but it isn't a residential area. People don't walk past as such. It's not a walk for the dog type area, and we. I mean, I'm just wondering if anyone has actually seen it, and I know it's been done lawfully, but I'm not sure it's given residents a fair chance to comment.
Well, thank you, Councillor. The application has been advertised in a lawful manner, but there are 3 areas that it can be advertised. First of all, given the size of the property, there were 3 blue notices on the side of the building. Admittedly, that was set some way away from the highway. Secondly, it was, as required by law, advertised in the local newspaper, Reading Today, under the public notices. And thirdly, of course, it's available on the Wokingham Council website.
Yeah, thank you, Bill. I accept that. I think the ways of publishing it are a bit outdated. Not many people today take a newspaper, and I'm sure most residents don't look at the website. And I think that we as a committee perhaps need to look how that's done in the future, so that local residents really do know what's going on. And I accept the fact that it's been done properly.
Thank you.
Mr. Rhodes has got his hand up.
Yeah, just to add to Bill's comments, there are residential areas further around Fish Ponds Road. So you to get to those places, I believe the only way is to go past our venue on Fish Ponds Road. So there would have been ample opportunity for those residents to see the blue sign.
Thank you, Mr. Rhodes. Rachel, you've got your hand up.
Yes, thank you, Chair. It was just one thing I wanted to cover off, just to see if effectively anybody had any observations before it's taken away or taken further. Bill raised and also Peter raised various mitigations on the brewing side, how long it took, and chimneys and things of that nature. Can I just clarify that my advice, subject to what anybody else might have to say, is the actual brewing isn't caught by the licensing application because it's not a licensable activity. The licensable activity is the sale and supply of the alcohol that is brewed. So that's potentially going to be a matter for planning, potentially going to be a matter for environmental health, but is not a matter for the licensing application, the Licensing Act or the licensing objectives. And I just wanted to put that out there now, because we have heard about the brewing process and I didn't want the waters to be overly muddied, unless anybody disagrees with my submission on that point.
Thank you, Rachel. That's very helpful, because I was about to ask a smell question.
Okay.
Thank you very much. Anybody else got any other questions? No. Okay, so if we move on to the yeah, go on. Oh, sorry, I didn't see that. Sorry, Kieran.
It's okay, thank you, Councillor. Helpful from our legal advisor, excuse me, helpful from our legal advisor steering there. Excuse me. I did have a question around a similar vein. So we know that the licensing application is for the sale of alcohol. So the sale of alcohol by retail, it's not an application for a brewery. So the environmental, the carbon filters and so on with the extraction, there may be an environmental Part B permit, which is a separate piece of legislation. And then we do have planning. But I do have a question just briefly around planning, but then the wider on the application itself. So, Bill, if you wouldn't mind, what hours have been applied for through planning, and have you had a pre-application consultation with planning officers?
The application has not been submitted. My clients have written to planning a few days ago, and they've not yet had a response.
Okay, but there's a reduction in hours in terms of the licensing application. Is that following suit with what you're intending to apply with the planning?
Yes. Yes.
So the two are aligned.
Yes. So at the moment, there's historic conditions on the planning side.
I understand.
Restrict the use of the properties across the whole estate between 7 a.m. and 8 p.m. in the evening. But of course, we are aware that other businesses may be trading later. We're not aware whether they've obtained the necessary consents, but it is our intention, 18 years after the original planning consent was given, to try and extend those hours, albeit to a modest 11 p.m. And those hours, those trading hours, are very similar to other public houses in the area.
Okay, thank you for your answer with that. In terms of the application itself, would you mind, Bill? Could we just hear from the applicants themselves in terms of just describing the plans for the sale of alcohol? So the sale by retail of alcohol. What are the plans in terms of the activities that might be had? Is it going to be a small shop area? Will there be brewery tours and so on? How is that taking shape? Because
sorry, Kieran, I'm not sure why this is relevant to a licensing appeal.
It's a licensing application, so the application itself is for the sale by retail of alcohol. We're not hearing an application for a brewery. So the only matter that the subcommittee are permitted to take decisions on is the licensing application for the sale by retail. So what's most important for the panel to hear would be the provisions around the actual sale of alcohol, because that's what the application relates to. So it may be useful to hear from the applicant in terms of what matters and provisions are being put in place there around the age verification policies, how the shop's going to be manned or used, or if there's any brewery tours. What's the modus operandi for the actual business, please, if you wouldn't mind.
I think I will defer to Ellen to just run through the operational side of it. But that said, you will see that the proof of age policy will be challenged 25, and within the conditions proposed by the police and accepted by my client is robust training documentation for all members of staff front of house. But Ellen, would you like to expand on that?
Yeah, sure. Thank you. So we will have a tap room. So for those that are not familiar with the word tap room, it's like a bar essentially. So we will operate as most other bars do in terms of sale of alcohol. People will be able to purchase drinks, sit down, enjoy their drinks within the bar area. We have also asked for off sale, so to be able to sell to people beer in cans, for example, that they can take and consume at home. As Bill mentioned, we would operate with the 4 licensing objectives in the core of what we do. So when we train staff, we actually train them on those licensing objectives so that they understand the need to meet those licensing objectives and the importance of that, operating in line with Challenge 25 policy, making sure our staff are aware of proxy sales, for example. We also operate with a robust process around recording anything that might happen or might cause a non-conformance against the licensing objectives. So we keep a strict log of non-sales. So if somebody did come, for example, and request to buy something, and we applied the Challenge 25 policy and we refused the sale, we would record that, and then we would discuss that with our team, for example, to make sure that they all understand and know that they did the right thing in line with the policy. Does that answer your question, or would you like me to elaborate further?
No, it does answer your question. And this is an expansion of your business as it stands. Could you?
Sure. So we operate a separate. Sorry.
Could you tell me, or could you tell the panel about that?
Yeah, so we currently operate a separate business within Wokingham Town Centre. So again, it operates very similarly to how we would expect to operate with Bearwood. And so although they would be completely separate businesses, they would operate in the same style, same manner, same customer focus and compliance focus that we operate currently.
Okay, thank you for your time.
And then in respect of children, it has been agreed with the police that no children are permitted on the site after 2100 hours. That is, of course, on the proviso that the licence is granted and the accompanying planning permission is also in place. So if everything went well and planning and licensing were granted through till 2300 hours, there'd be no children under the age of 18 allowed on the premises after 9 o'clock.
Thank you, Al.
Thank you. So has any of that generated any other questions from the members of the panel or anybody else? Yeah, no?
Ma'am, if I may just add something to the submission. The reason that we were discussing the potential about potential smells coming from the property and so on is, of course, one of the 4 licensing objectives is preventing the public nuisance, and smells might come under that umbrella. And that's why I wanted my clients to explain to the committee some of the aspects of the air filtration systems.
Thank you, Bill. Actually, in that case, I will ask the question I was going to ask, which is, how far do the smells normally drift?
I'll defer to Peter for that.
So, for example, using the outhouse brewery as an example, the smells drift as far as 30 yards away, 40 yards away at the most. Even though the brewing is bigger at Bearwood than it is at the outhouse brewery, it's still relatively not much more steam than what's produced at the outhouse because of the chimney sizes, etc. It's just a general, I guess it's hard to explain, but if you've ever gone around the breweries on a brew day, you just get to know these facts. So I don't envisage there will be much smell, if any. If it does, I really don't see it getting as far as any residential issues. It's a good question. It's hard to answer without being there with a monitor, I guess, to measure it.
Okay. And what hours are you intending to produce smells? I mean, so, I understand you said 1 hour for every so often, but would that be during the working day, or would it be in the evening or at weekends? Or
correct, yeah. So a typical brew day, depending on the brew, will either start at 8 or 9 a.m. They'll do their mash in for an hour, which are no smells generated. Then they get to the boil. So the boil usually happens at 11 a.m. to midday, and that will be fairly consistent with each time the brew day happens.
And that wouldn't be at the weekend?
Correct, yeah, only Monday to Friday. Generally, they're normally brew days Monday to Wednesday, but we would say Monday to Friday just to cover us.
And would that be every day?
No, I think you already said that.
Yeah, so it would only be, we only have capacity to brew 5 times every 2 weeks. So we'll brew a three week and then a 2 week. I would love to do more. We're just not big enough.
Thank you. And just a follow-on question, what about delivery of the things that you're going to be brewing? Is that, what sort of?
Yeah, so there are various forms of delivery. One of them, there are 2 major platforms in the UK where bars around the country buy online. and they're brilliant in respect of UPS will turn up in the morning and collect just like a package. There is the delivery of local sales, so that will be like a transit style van. And cans online again would be a UPS delivery. So no different from any other thing on the industrial estate as it happens.
And how about your raw materials?
So raw materials, they're generally either lorry or van, depending on what it is. Again, no different from what we've seen of other deliveries on the estate.
Okay, thank you. Sorry, has anybody else got any other questions? Sarah?
It's just going back to the description that Bill said it was a tap room, and going back to the sale of alcohol on and off site. There are several types of brewery, and it's also been coined microbrewery. So what's clear, are we dealing with a drinking establishment, as in the majority of the sales are on site? Or are we dealing with something that actually more than 75% of the sales is off site? So, and that's important to consider in terms of comings and goings, but also the hours of operation as well. And so that's where obviously the difference between planning and licensing, but in terms of crime and disorder, that side of things, you need to consider that as well with the sale of alcohol.
Yes, well, we are applying for this committee, we are applying for a premises license to authorise the sale of alcohol. So it is an on licence, which also permits off sales as well. So obviously as a tap room, we are creating a pub on the industrial estate. Now, the level of sales in terms of delivery is probably yet to be determined, but there are legal definitions of what is a microbrewery as opposed to a full-on, full-scale brewery. But maybe, Peter, I would ask you to comment on the split, the anticipated split of on and off sales.
Yeah, thank you. So hopefully to easily define, with the brewery sales, we're actually covered under the AWRS license, which is the Alcohol Wholesale Retailer Scheme, if you're not familiar. So we're bound by licensing laws around that. For the tap room itself is what we're here today for, the premises license. So I can talk about the split of sales if you wish. In my opinion, I'd submit that I don't think it's relevant for what we're talking about today.
Can we have a view from Woking Borough Legal on that? Rachel?
In terms of the planning?
No, in
Sales,
terms of whether
sales.
it's a relevant consideration about the split of sales.
Not really for the purposes of the licensing objectives, unless you think any of them are likely to be engaged by that.
Yes.
Yeah, the only question would be the public nuisance, I think.
Yes, and Mum, if the police had concerns, then I think they would have continued with their representation. But there is fairly comprehensive conditions that relate to the management of the premises, of which my clients will adhere to. And of course, any breach of any conditions of a premises license, the penalties are really quite severe.
Thank you. Is there anything WBC Legal would like to add? Rachel, are you happy with that?
Yes, I mean, it's tricky, isn't it? Because you can't anticipate how much is going to be on and how much is going to be off sales with any kind of degree of certainty. It's whether there is going to be a public nuisance caused by that, and whether, not just whether you think it's likely, but whether there is a genuine and substantial risk of public nuisance that can't be overcome by conditions. And it is always difficult when it's a new application versus a review. But what I would say, talking about reviews, is if if things are not as presented, or if public nuisance is present, if you were to grant the licence, any licence is always open to review if that situation were to arise. And I'm not saying in saying that you should grant it or not grant it. I'm just saying it's very difficult to establish what it will be till it happens.
Thank you, Rich. Kieran, you got your hand up?
Yes, it's it's an interesting take out. It's a new premises, but the applicant is of experience locally. It may be worthwhile just having several questions on, while it's not this application, just several questions on their maintain license in the Workingham town centre. Just for the ability to draw contrast. Could I ask, in terms of the crime disorder elements for the brewery tap in Wokingham, how many incidents have you had over the last 6 months, and how are they managed?
I think you need to get the name of the premises correct.
Sorry.
Yes. Ellen, I'm going to go over to you.
Yeah, so in terms of public nuisance, we haven't had anything since we opened. I think it's probably important to mention that when we're talking about off sales for this particular license, we're talking about customers that might order at the bar and say, I want to take some cans home with me. We're not necessarily talking about shipping or delivering things to customers' home. Whilst we have the ability to do that, the off sale tends to come from people walking in like an off license and saying, hi, please may I buy these and take them home with me.
Thank you. Kieran, have you got any other questions?
No, just my apologies for House Brewery. Thank you.
No, I thought that was a useful question. Has anybody else on the committee got any questions? I see a no. Right, so we'll go on to the objector. Andy.
Yes, to be honest, I only saw the additional application probably 20 minutes before this meeting. So as you can imagine, I wrote down some notes that probably aren't quite relevant now. So I'll just cut to my main concerns. I'll be as quickly as possible, and you can take it or leave it. Main one being sound, because there was the application for live music. And in the dividing wall between our two units, we actually had that built because we used to own Unit 11. And there's no soundproofing in that at all. So during the day, as you can imagine, we have customers, we have meetings. And so that was our major concern, is being able to hear that sound throughout the working day, and even just having meetings like this with customers over the phone and suppliers, being able to, trying to avoid that sound, as it were. That was my main issue. Sound, I know we said about no external seating. Now that was another concern, but you've taken that out. Safety was one of our other big ones, and in that, the additional, it's been stated that the LPG container is going to be relocated to a base that is controlled by the estate manager, not the landlord. However, the estate management is ran by two people, and the landlord is one of those two people. So it's been in his interest to advise that, because it's helping out Unit 11. I tried to speak with the other management company member this morning, but as you can imagine, I only saw it 20 minutes before this meeting, and I wasn't able to get hold of it. And I'm pretty sure he wouldn't have agreed that. Regardless of that, there are still covenants on the estate that says you cannot have an LPG container, because you can get the supply of gas through a conduit, which is a pipe, meaning a main supply, but you cannot have a container, because a container is not a conduit. And we've taken legal advice regarding this, and he's advised that that shouldn't be on the premises or on the estate, because the same covenants cover both the unit and the estate at the same time. So that has been an ongoing thing, and that is my other concerns have been withdrawn in those additional applications. They're the only real concerns that I have moving forward.
So thank you very much, Andy. So Rachel, would you mind giving us a view on those two complaints and whether they're within the scope of licensing, or two objections?
So I'm not an expert in conduits and LPG and things. I go back to my original point that while brewing, which I think the conduits and the gas and everything relate to, are very valid points raised, they go to planning and environmental health. They don't go to licensing, because if you were to refuse this license today, there's nothing licensing wise to stop the brewing taking place. There might be planning things and there might be environmental health aspects, but in terms of the Licensing Act, that is the supply of alcohol, not the creation of alcohol.
Okay, thank you, Rachel. And the point about noise?
The point about noise, well, we've lost the point about noise that I think Mr. Goodwin was concerned about live music impinging on him being able to run his business, and live music, it was applied for as a separate licensable activity. You will note now, of course, that application is no longer before you. Recorded music is allowed without there being an application for it under certain circumstances, and effectively due to deregulation, one can now have recorded background music between the hours of 8 and 11, I believe. Kieran will jump in if I'm wrong, as long as the premises has an alcohol license for the day that's being played. So once again, as a subcommittee, you don't have any control over that activity because it's out of the scope of the Licensing Act now. But there can't be any live music if there isn't.
So recorded music would again be a planning point, would it? Because you could, I think I've seen in planning permissions in the past, limits in terms of decibel levels and that sort of stuff, and the requirement to put in noise limiting equipment.
Mark, can I assist in this matter? Of course, background music is not a licensable activity.
No.
So music generally played in a supermarket, a restaurant, or indeed the tap room doesn't come under the remit of the Licensing Act. Although it's slightly misleading because, of course, it is recorded music. Recorded music only becomes a licensable activity once it becomes a level where it's an entertainment level rather than simply background music.
And how? And is this a planning issue, guys? That's what I'm really pushing at. So, in order to protect the next door neighbour from the ability to continue his trade and the level of interior music, is that a planning issue? Maybe the planning officer could answer that.
Yeah, it's the whole package. So you're looking at the how the hours of operation and the timings of everything. So yes, that would be encompassed in any planning forthcoming application, really.
Thank you, Sarah. So the next door neighbour can put a representation into planning about restricting noise if he wishes to. Okay, thank you.
And there's also, just to throw into the mix, there's also environmental health that may have a skin in the game when it comes to noise as well.
Hopefully that's helpful, Andy.
Yes, it seems like it's more the planning side than the licensing side. My concerns, it seems like.
Yeah. Okay. Has anybody else got any questions for Mr. Goodwin? That looks like a no. So has the applicant got any questions for any party here?
Well, I'd just like to ask Mr. Goodwin, given the amendments we've made and probably a more detailed description of how the business intends to operate as a tap room, are you more comfortable with the operation now?
Yes, more so. My only real concern is the hours going up till 11:30, and the usage, because you said the mezzanine is for the B1 use, it needs to be 700 square foot, but I'm pretty sure that mezzanine is larger than 700 square foot, so that would then maybe not classified as B1.
No, what I said was that the overall footage of around 4,200 square feet, only 700 is allocated to the brewing process. But as it's been highlighted today, of course, we're considering the application for the grant of a premises license that actually relates to the tap room.
Okay,
that includes the brewery, but the brewery in this application is a separate entity.
Okay, yeah.
Okay, so I believe that the applicant has got the right to sum up if they want to.
Yeah.
Oh, sorry, Rachel.
Just before he does, I know you raised earlier wanting to know a little bit more about Andy's business.
Yes, I did. Yeah.
And through you, Chair, can I ask Andy what your business is and what hours
Thank you for
people are
reminding
working and things? No problem.
It's mainly distribution, so we sell banking equipment online, so it's the distribution of electrical goods. So we'll typically get deliveries of HCVs of our stock, and then we'll get daily collection from a courier to distribute our sales.
Okay, thank you. Thanks. That's helpful to know. So would the applicant like to sum up?
Ma'am, before I do so, I'm aware that planning made a representation, and I wondered if they wanted to present their case first.
Quite happy with that. Thank you for that.
Okay.
Sorry, Sarah.
Okay. So obviously the original application has now been revised. It was just drawing the attention to the applicant of the lawful use of the business, but also that we had concerns over the hours of operation, and that really when you're looking at the license, that it needs to reflect reasonable hours that don't amount to any nuisance. The original permission, as Bill has said several times, is between 7 and 8 o'clock Monday to Saturdays, and nothing on Sundays and bank holidays. I note that the application is through till Sunday, 11:30 operation. So also the selling of alcohol is a different time. That's up to 11 p.m. my understanding. Is that correct?
Yes, that is correct.
Yes. So in terms of staggering the hours as well, and you may want to look at also with sales, the element in looking at the times for sales on site as well as off site. It's that's open to you. But at the moment, the original permission says 7 till 8 and nothing on Sundays or bank holidays.
Okay, thank you, Sarah. Right, would you like to sum up?
Mum, thank you for that. Well, the application in itself today is what I call a vanilla ice cream application. It's a straightforward application for the grant of a premises license as amended in the skeleton argument from 8 a.m. through to 2300. It's the tap room that's being licensed at the moment. The brewing side is a different issue in respect of planning. My clients are cognizant that there are restrictions both in terms of use for the brewing side and operating hours, but that will be part of a separate planning application. We've agreed conditions with the police. Environmental Protection have not objected, neither the Fire and Rescue Service. So there's obviously no concerns, and the police would be the experts on crime and disorder. there's no concerns about how the premises are intended to be managed. So we would ask the committee to consider granting the licence as applied for and as amended in our application for the sale of alcohol, notwithstanding that my clients recognise that they can't move forward until they've resolved the planning issues. Chair, that is my submission.
Thank you very much. Has anybody else got any questions or any clarity that they require? Or do they want to make any other points? Beth? No? Jackie? No? Anybody else? No? Okay, I will call this meeting to a close then, and we'll let you know in good due course.
Okay, thank you.
Thank you.